All right, now we're ready to start whenever you guys are ready.
Great, thanks, Evan. Welcome, everyone. Good morning and good afternoon and evening to those attending virtually in the other time zones. As Evan said, my name is Adam Crane, and I'm a partner with Baker & Partners in our Cayman Islands office, where I focus my practice primarily on complex and cross-border insolvency, restructuring, and asset recovery proceedings. I'm also a member of the executive committee of the NextGen program. Thank you to everyone attending, and a special thank you to the III for hosting these NextGen sessions today. Today, I will be serving as the moderator, and you'll be hearing from my friends and fellow Class 9 members, Maja, Zerjal, Fink, Ilya Kokorin, and Jose Carlos. Maja is a partner in Arnold & Porter's bankruptcy and restructuring group. She represents clients on all sides of distressed matters and has worked on a number of high-profile restructurings, including the Hertz bankruptcy, Puerto Rico, Caesars, and MF Global Holdings. Maja has been recognized by the American Bankruptcy Institute in its 40 under 40 class of 2020, Law 360 in 2020, Super Lawyers in 2020, and as a rising star in the Legal 500 in 2019. Ilya is a PhD candidate at the Department of Financial Law, Leiden Law School in the Netherlands. His research focuses on the topic of enterprise group insolvency. He also explores how new technologies such as artificial intelligence and blockchain affect and transform financial practices, as well as the rules of financial, corporate, and insolvency law. And last but not least, Jose, ex-investment banker, chartered economist, and lawyer. Jose is the founding partner of Spain-based law firm Carlos Cuesta, where he leads the business recovery, restructuring, and insolvency practice. Jose is the co-chair of Insol Europe's Legal Tech and Digital Assets Wing and co-editor of Insol Europe's insolvency journal, Europhoenix. Like Maja, Jose is also an ABI 40 Under 40 award winner and is in exceptional company in the same 2019 class with our former and current NextGen leaders, Yvonne and Evan. Although we would all love to be there in person with you this week, it is fitting that we are all virtual for our panel on COMI in the digital age, determining COMI of a digital business. Despite our panel title, our paper took a more narrow focus where we looked at the concept of COMI of decentralized autonomous organizations, which we will refer to as DAOs. Don't worry, we'll explain what this means if you've never heard this term before. So as my daughter says on her YouTube videos, let's get into it. The concept of center of main interests is essential to international insolvency law, as it can assist in determining jurisdiction, applicable law, and the cross-border recognition of foreign main insolvency proceedings. Under the European insolvency regulation and the UNCITRAL model law, there is a rebuttable presumption that the center of main interest of an entity is its registered office. The task of determining a company's COMI is relatively more straightforward for a brick and mortar business and a typical investment fund. However, the determination of COMI becomes more difficult when we are working with newer business models that are purely in the digital realm, such as DAOs, which are typically not registered as legal entities and do not have registered offices. These businesses have little connection to a particular jurisdiction. Throughout this panel, we will look at COMI and its relevance, the concept of DAOs, the challenge of applying the COMI analysis to DAOs and other digital businesses, and we'll conclude with how the COMI of these businesses may be determined. So Jose, why don't you set the stage and explain what is COMI and how it is relevant?
Yes, yeah, of course. Thank you very much, Adam. Well, I think it's actually good because I'm from Spain, so I'm European, so that I speak about the concept of COMI because it actually has a European origin. COMI was created as a concept in the 1980s in the draft convention on bankruptcy winding up arrangement, compositions, and similar proceedings. And although it was the times of the ECC, like the European Economic Community, it was not even the European Union. The concept in the draft law was basically where the debtor administers his main interests. So as a concept in Europe, I know in the US, you are more used to thinking of COMI as you know, where the nerve is. In Europe, we think more of where the brain is, basically. So in this draft convention, it actually gave the exclusive jurisdiction to declare the debtor bankrupt. And well, this actually was also included in some conventions that didn't actually enter into force, as the Istanbul Convention or the European Convention on insolvency proceedings. So it was basically in 2020, in the 2000, sorry, and 2015, with the European Insolvency Regulation and the European Insolvency Regulation recast, where we actually had the concept of COMI actually included in Europe. And I will first actually say why it's important, then I will start defining it, and then we will also have Maja explaining it from the side of the model law. It's essential in cross-border insolvency. Actually, for example, from my perspective, European perspective, it determines the application of the European insolvency regulation. So if COMI is located in one of the member states, excluding Denmark, it actually determines that the European insolvency regulation will be applicable. It determines the exclusive jurisdiction of a country within Europe in order to open a main insolvency proceedings. We have automatic recognition among all the member states. It also determines actually the applicable law. So we actually go beyond the modern law in this. It's the applicable law that applies to the insolvency proceedings and some of their effects, which normally is the law of the opening state, with a lot of exceptions, of course. So actually, COMI is a very relevant concept, and we're going to kind of summarize very briefly what it means for a traditional business, in order to then see what happens with these new virtual businesses and the problems it may pose. So we basically all know that COMI is defined as where the debtor conducts the administration of its interests on a regular basis, and as it has to be ascertainable by third parties. So as Adam explained, there's a rebuttable presumption that it will be the place where the company has its registered office, but this presumption actually can be rebutted. So it means that actually COMI could be located in Europe, even if the registered office is not located in Europe. This was, for example, what happened in Ray Rent-A-Car International, which was basically a US company that was incorporated in Delaware. So, well, we would think COMI presumption, it's in the US, COMI is located in the US. But actually, the company basically didn't trade in the US and had no employees in the US. So basically, the trading was in the UK, the employees were in the UK, their contracts were governed by English law, contracts with third parties were also governed by English law. So basically, in that case, it was determined that the administrations of the interests and basically took place in the UK. So COMI can actually be located in Europe, even if the registered office is not located in Europe. We could say, therefore, that in Europe, we follow not the incorporation theory, I mean, not the incorporation theory, but the real seat theory. And that we need to have two cumulative criteria in order to determine COMI, which are basically the fact that there is an administration of the interests on a regular basis, and second, that it's ascertainable by third parties. What factors are being taken into account in Europe? Well, basically, where the business is carried out, where the staff is located, where the tangible assets are located, where the interaction with the creditors takes place, and there could be other criteria, such as where the bank accounts are located, or where the directors actually have their place of residence, but these are actually less important. just to say that we all know, I think, Eurofood and the standards it set for a certain certainability of of this administration of interests, which is actually what has been determined in Europe. It was one case regarding letterbox companies, and in this case, we also saw that the only fact that a company is controlled by a parent company which is located elsewhere would not be sufficient criteria in order to rebut the office presumption. And well, this ascertainability was taken further by Interadil, which is also a case that I think you all know. And just to finish, in Europe, there's no thing such as group COMI. So if there are several entities within a group, we will have to look at well, the separate legal entities in each country. It could happen that if really the COMI is located in one single jurisdiction, then it is located in one single jurisdiction. But the normal thing would be that each of the companies would have its single COMI, but it would have to be assessed on a case-by-case basis. And well, it's not exactly as I said. Europe looks at the head, and the US looks more at the hands, at the nerve, at the hands. Sorry. So I will let Maja talk about this.
Thank you, Jose. So I will talk about the model law, and I don't want to repeat too much because thankfully the model law follows a lot of what the European insolvency regulation established. So COMI is central to the operation of the model law. Where a company has its COMI, the proceeding will be recognized as a foreign main proceeding. And that's important because certain relief is granted automatically upon recognition. For example, the automatic stay kicks in. That's not like in a foreign non-main proceeding where certain relief needs to be requested separately. I mean, technically it's, I think as a general matter, granted, but again, it needs to be requested separately. Much like the European insolvency regulation, COMI is also presumed to be in the place where the debtor has its registered office, but that can be rebutted. There's no statutory guidance as to what evidence one needs to present. Like Jose said, there are several factors that courts have considered, and there is an uncitral guide to the enactment of the model law that suggests that courts should consider the totality of evidence to ultimately understand where the actual location of COMI is. And similarly to the EIR, it should look at a place that is readily ascertainable by creditors. So the guide does list out a number of factors. I'll run through them because in our quest to find the COMI of virtual businesses, we try to hold on to what we have available. So the following locations are what the guide suggests. It's the location of the books and records, where financing is organized or authorized, or where cash management is run from. It's the location of the principal assets and operations, the bank, the primary bank, the employees, where commercial policy sales are determined, where the staff and accounts payable are administered, where the main supplies are organized, where the law is that applies to most disputes. It could be the jurisdiction where the debtor is subject to supervision or regulation, or it could be the location whose law governs the preparation and audit of accounts, and which is the place where the audits are taking place. So look at these, 13 or so factors. I would probably boil them down at a high level in really three buckets. It's one, the location of the assets, which is, physical assets, I guess, traditionally. Two, it's where the operations and the administration take place. And three, it's the governing laws for the main contracts that govern the operation of a company. So I'll note some of the early decisions, much like Jose did, that interpreted COMI, and it quickly became apparent that the court has an independent duty to make sure that the statutory requirements are satisfied before recognition can take place. Interestingly enough, the first notable decision in the US went in the opposite direction. You're probably all familiar with Fink, where a hedge fund was registered in the Cayman Islands, but mostly operated out of the US. And in that case, the judge did not grant recognition for other reasons because he thought the proceeding was commenced for improper reasons, but otherwise said that because there were no objections and the creditors were okay with the main proceeding taking place in the Cayman, he actually would have recognized it, therefore basically giving deference to where the creditors' agreement about COMI was. The decisions that followed, Bear Stearns and others, went the other way, fairly severely criticizing the Fink's decision and noting that the court should not rubber stamp where COMI is. And therefore, while some credence may be given to the creditor's agreement, there should be steps that are taken to actually ascertain that the requirements are met to determine where COMI is at the time of the application. Since then, that was 15 or so years ago, there have been many decisions that interpreted COMI that looked at the various factors enumerated in the model law. Many courts also followed European decisions. And many courts also dealt with COMI shifting and frankly, COMI manipulations. And so just to mention two on the opposite sides, there were decisions where COMI shifting was found to be okay and found to be done for good reasons. A decision in Oceanrick found that COMI was probably transferred to the Cayman Islands. It was originally incorporated in the Marshall Islands, where the administrators took steps a year before starting the proceeding in the Cayman to shift COMI by moving the registered office, by holding meetings there, by having certain members of the management in the Cayman Islands. And the primary reason for the shift was because the restructuring framework that was available to them in the original jurisdiction was simply not sufficient to implement the restructuring that they wanted to implement. And therefore, the court in the United States recognized the proceeding, finding that that kind of shifting was actually proper. On the other end of the spectrum is the decision in the Brazilian case of Oi, that I think a lot of you are probably familiar with. There, a Brazilian proceeding of a group of companies was recognized. One of these companies in the group was actually registered in the Netherlands, and following recognition of the Brazilian proceeding, there was a proceeding started in the Netherlands, and the trustee was seeking recognition of that particular proceeding. The circumstance there was different because there were no material objections to the initial recognition of the Brazilian proceeding, and it was really a strategic play by a particular subset of creditors there, and the court found that to be an improper purpose for COMI shifting. But we'll talk more about COMI shifting and potential manipulations later on. I'll hand it back to you, Adam.
Thank you, Jose and Maja, for setting the stage for this analysis. Let's move on to the concept of DAOs. And I have to confess, up until our first planning meeting for this panel, I had no idea what a decentralized autonomous organization was. Quite frankly, I'm still a bit fuzzy about the purpose and utility for them. But thankfully, Ilya is, I won't say an expert, but he fully understands DAOs. So he will explain what they are, give an example of DAOs and what they typically do.
Thank you, Adam, and thank you, Maja and Jose. Yeah, happy to give a brief introduction to the concept of a decentralized autonomous organization. I believe in the future we'll hear more about them. It's important to understand that the technology that underlies the existence of decentralized autonomous organization is the distributed ledger technology. And the best and the most known example of such a technology is indeed blockchain, that allows the recordings of transactions without an intermediary, so in a decentralized way. And of course, after the global financial crisis, there was a lot of distrust to governments, to banks, and blockchain offered a good solution to transact with each other without having an intermediary involved. We all probably heard of Bitcoins and other cryptocurrencies, but blockchain can be used for other purposes other than trading in crypto assets. And one of those ways is the creation of new blockchain-based organizations, so-called decentralized autonomous organizations, or DAOs. The Coalition of Automated Legal Applications, or COALA, which is a research initiative, really international research initiative, has recently published the model law for DAOs. And that's, so how do they define what a DAO is? So according to the definition suggested by COALA, A DAO is smart contracts, blockchain-based software developed on a public permissionless blockchain, which implements specific decision-making or governance rules, enabling a multiplicity of actors to coordinate themselves in a decentralized fashion. And of course, the question is then, the DAO is a smart contract. So what is a smart contract? So it's another terminological issue that we may run into. Well, smart contracts as a term has been used actually since the 90s. And one of the creators of this concept, Nick Szabo, has defined it as a computerized transaction protocol that executes the terms of a contract. So essentially, a smart contract is a self-executing computer-coded agreement. And therefore, if we put those two definitions together, we will realize that a decentralized autonomous organization is essentially a code or an algorithm that is established on blockchain that allows participants to govern themselves. So the code allows certain decisions to be made and to be executed automatically and in an irreversible way. For instance, you can agree that upon a certain voting, a certain transaction will be implemented without having to have any director or any other intermediary actually implementing such a transaction. And to give an example, what a DAO is and what a DAO can do, one of the most famous example is the DAO. So not to be confused with just a DAO. So the DAO was indeed a venture capital vehicle that was created in 2016. So over 2 months, it attracted more than $100 million US. But unfortunately, it's a sad story. So because there was a hack, as some people refer to it, so there was a weakness in the code, it had to stop its existence. But initially, the idea was to allow participants, so those who invest in a decentralized autonomous organization, to make decisions, and those decisions would be whether to invest in a certain project or not. Another example, which is still alive and kicking, getting more and more subscribers or participants, is a crypto social club called Friends with Benefits. So what Friends with Benefits does is it invests in its own creative communities using cryptocurrency tokens. So Friends with Benefits essentially is a decentralized cooperative where everyone pays in and everybody participates and helps each other. So if you would like to learn more about Friends with Benefit, just have a look. It's quite an interesting initiative to look into. And of course, the question then is, okay, so now we understand that DAO is a smart contract that exists purely on blockchain. So there are no directors. Most of them are not registered. So how are they treated under law? And the first question is, are they recognized, or can they be recognized as a legal entity? And unfortunately, there's no clear answer to this. And if a DAO can be recognized as a legal entity, the question is, do members of a DAO have limited liability? So it's even a more difficult question to find an answer to. But luckily, in the United States, in the summer of this year, Wyoming passed the law referred to as Decentralized Autonomous Organization Law. So since the 1st of July 2021, it is possible to register a decentralized autonomous organization in the state of Wyoming. And this decentralized autonomous organization will be treated as a limited liability company. Of course, there are a few requirements for the registration of a DAO in Wyoming. So for instance, there has to be a registered agent in Wyoming. Articles of association or organization of a DAO must include a publicly available identifier of any smart contract directly used to manage, facilitate, or operate the DAO. It's quite an interesting development. So I think Wyoming is by far the most developed jurisdiction for the establishment of DAOs because it does recognize them, allows them to be registered, and also grants limited liability to the members who want to invest in a decentralized autonomous organization. Of course, there have been some talks in Malta and a few other jurisdictions, but there we haven't seen the developments yet.
Great, thanks, Ilya. Let's move on to the interplay between COMI and DAOs. Jose, how does the COMI analysis fit in with DAOs, or at least DAOs that have a registered office, like in Wyoming?
Yes, it's basically as we explained in the first part, there's a presumption of COMI being located where the registered office is. So actually the fact that Wyoming allowed DAOs to be registered would make it easier for us to find COMI when DAOs are actually registered. But we understand that there won't be that many DAOs that will actually be registered. So the question is more what happens actually with those DAOs that will actually will not be registered. Will this traditional criteria that we were talking about in the beginning under the European insolvency regulation or the model law make it, or we will need to think about something different?
Thanks, Jose. And turning this over to you, Maja, how would courts determine COMI of a decentralized business, especially one that does not have a registered place of business? And what are some of the issues that arise when determining bankruptcy jurisdiction and COMI of a digital business, including DAOs?
Thanks, Adam. I think the fundamental question before even going to how courts would determine that is the notion that these businesses really arose out of a desire to be self-regulated and illegal, if you will. So much like the original DAO, I think for me, the question is, would these entities actually want to be regulated by traditional frameworks of insolvency as we know them today? Because as we'll discuss, and as you probably understood from Ilya's remarks, these are not necessarily entities that have tangible assets and that could be regulated the way that a brick and mortar business could be regulated. But leaving aside the question and assuming that somebody could try to commence, say, an involuntary bankruptcy against the DAO, right? There's a lot of questions about it. Like we said, there's no particular tangible assets where you could say, of course, if we don't have registration, right? There's the headquarters, there is management, and so forth. So there's a couple of things that we could try to hold on to try to link the very specific characteristics of these organizations to the factors that we have available. We could look at how decisions are made. Obviously, DAOs are established at some point, even though the code is implemented and it's supposed to then run automatically, somebody does set it up. So you could potentially look at the people who set it up initially, even though later on they're pretty much out of the picture. We could consider where certain assets like intellectual property is located, even though these assets are probably not located in one specific place. And we'll talk about it later, how the location of these can shift. We could look at the place where the members are located. But again, the problem with blockchain and Bitcoins and whatnot is that it is the one thing that has no borders whatsoever. And there's very little regulation that applies to it. Speaking of regulation, we could look at where regulations apply. For instance, if the SEC were to go after a certain DAO, I'm sure that somebody would consider starting a proceeding in the US and try to link it to enforcement action. Similarly, how do you sue a DAO? What is the applicable jurisdiction? So in my mind, those are very similar things. So going back to the three buckets that I mentioned earlier, which are the assets, the management, and the governing law. I think that the courts, if they were faced with this question, would try to apply the available characteristics to the factors that we have at hand, no matter how weak they are, because that's simply all we have. So in light of that, we could look at, like I said, the location of the human oracle, a foundation that might be supportive of the DAO or other entity that's supporting it. And could find that to be the so-called location of administration of interest. They could look at any contracts that the DAO enters into and see what the governing law of such contracts is. And like I said, if there's any lawsuits or any regulatory action, that could be a factor that could be used in that determination. But like we said, that approach is not ideal. And it may be subject to a lot of abuse because these factors are all very transient and not particularly stable. But more than that, it could simply just not capture the spirit of either COMI and the spirit of DAOs.
Great, thanks, Maja. Ilya, given the decentralized nature of DAOs and other digital or internet-based businesses, the lack of hard assets, and the likely ease of manipulating factors relevant to COMI, are there ways to prevent the potential abuse of COMI migrations or bad forum shopping?
Yeah, thank you, Adam. Well, I don't think I have a magic answer to this question. I think the problem is, of course, that the COMI itself, as Jose has mentioned, was developed in the 70s and 80s, when most of the businesses were not digital businesses as we are discussing today. So the idea of COMI as the center of administration has traditionally been linked to hard assets. And here, as you pointed out, we don't have hard assets, so we're dealing with digital assets which don't necessarily have any specific location, and it's so difficult to pinpoint or connect, let's say, a cryptocurrency to a specific jurisdiction. The management, as I pointed out, is really decentralized, so we don't have a director or a manager that we can point to and say, okay, the management is in a certain jurisdiction, because it's inherently democratized and everyone who invests in acquires certain voting rights. So then we can say the management is actually around the whole world, in every country where the token holders are located. So I think the similar problem arose in the 90s and is still pretty much there when we talk about connecting factors related to the internet use. So in the European Union, we have very mixed cases related to, for instance, the jurisdiction for claiming damages arising from defamation made online. So if we have a website that contains certain information that, for instance, breaches personal rights, where can a victim sue? So in which jurisdiction? Because the website is available throughout the whole European Union. So the Court of Justice determined that actually you can sue in every jurisdiction, but also only for a certain amount of damages in that specific jurisdiction. So it's a bit messy, to be honest. So and I think we're still seeing the development of case law related to dispute related to internet. I think the general idea could be to focus less on the assets because they're really digital and not linked to specific jurisdiction or management, but look into the protection of stakeholders and the issue of ascertainability, as was pointed out earlier today. Ascertainability is the key concept to look into because it determines protection of stakeholders and creditors in particular. So I think these would be just a few points that I would like to raise, but it's very difficult to answer in a very easy way, unfortunately, Adam.
Thank you, Ilya. And Jose, what are the conclusions that our group has come to in terms of locating COMI of a DAO?
Yes, thank you, Adam. It's actually, we have been kind of talking about it during the session, but we need to take into account what we said in I think it was Maja and also Ilya. DAOs, they have a nature of self-governance and a code-based existence, and they basically tend to be detached from any particular jurisdiction. So maybe they actually find solutions that are, as Maja said, elegant, like they decide how they want to wind up, how they want to reallocate and distribute the assets if they have issues. So maybe the solution for a DAO wouldn't actually even be an insolvency proceeding. So that's one thing that could be there. And one thing that we will have to see is if actually this is included, these rules for winding up will be included in the code itself of the DAO. Another thing could be that actually the code is public. So if the DAO would actually include in the code that the jurisdiction, if they need to file for insolvency, would be one, well, what happens there? And as we said, we have this evolution in Wyoming, which actually gives us a place of registration. So at least in Wyoming, if there are registered DAOs, it would make it easier. But what actually would happen in other cases when there's no place of registration, because there are no other traditional criteria that we can apply, like there's no centralized management, there are no hard assets here. Like even if we have the registration in Wyoming, how would we actually rebut that? And if there's no registration, how can we do it? So actually, Maja posed many questions, which would be actually the conclusions that basically we came up with, which would be: do we need to look at where the decisions are being made within a DAO? This is actually a bit complicated because it's like, do we have to look at where the members are, which actually can be thousands and spread in many jurisdictions? Do we have to look at the oracles or at foundations that actually support or entities that support the DAO? So do we have to look at those? Do we have to look at the assets, as Maja said, like what the IP, but where's the IP stored, for example, or where the blockchain-based assets? The problem here is, where are these assets actually? Because we cannot really be precise about their location, as Maja said, like they are anywhere and everywhere. And actually, we would also have a problem of, even if we could be precise about where they are, would it be ascertainable for third parties? I think it would not. So if we look at the location of the members, should we look at the country with more members? Should we look at the country with the members that have a higher stake in the DAO, for example? So there are basically many factors that we could look at, and the conclusions we had were that basically for a traditional company, if you have weak factors, then you could not determine COMI. But maybe for DAOs, as there are no strong factors, maybe the fact that there are some weak criteria or some weak factors could actually lead us to think that there is a COMI somewhere, and that could be sufficient. For example, as we said, the location of the human oracle or the foundation or entity that supports the DAO, because it's the only ascertainable criteria that can lead us to the location of the administration of interests, and therefore to determine COMI. Or, for example, the contracts that are entered by the DAO, or the law which is stated in the DAO's white paper, which actually can indicate the law that governs the contracts of the company, and then can lead us to the DAO. Or as Maja stated, if there is regulatory action or there are any claims against the company, maybe this can actually also allow us to state a COMI or a COMI link with the DAO. So basically, those were the conclusions that we reached. And I will let my colleagues Maja and Ilya talk about it a bit more if they have any other comments.
Thank you, Jose. Yeah, Ilya, rather than relying on the typical factors for determining COMI, should DAOs and other digital businesses rely on COMI or forum selection clauses? What potential problems do you see with this approach? And are there any other solutions?
Thank you, Adam, and thank you, Jose. I think the problem is, like, if we really look into the why we have blockchain, why we have cryptocurrency, why we have decentralized autonomous organization, is that we want to actually escape from the legal realm. So I think the concept that Maja mentioned, illegality, is critical here. So and we try to squeeze these concepts in the legal realm. So we try to find legal solution to something that was trying to escape the legal rules to start with. But we have seen already with cryptocurrency that it's really difficult to totally distance yourself from legal rules, and that's what we try to do in our papers, to see how legal rules can actually maybe help in one way or another protect the interests of stakeholders in the concept of a DAO. And I think we talked a lot about how difficult it is almost impossible to use the traditional criteria for the COMI determination and apply those criteria to DAOs. But what I found interesting and what I think could be the future for these types of organizations to create legal certainty is to allow them to self-regulate the place where they think they want to have a COMI or a forum choice. I mean, the idea of allowing companies to choose the insolvency forum is not new. Robert Rasmussen has suggested that companies should be allowed to choose the COMI in their articles of association or the corporate charters. This idea, of course, was heavily criticized because some people claim that it gives too much power to debtors. Also, debtors may choose to change corporate chapter and therefore change the location of COMI. So there were all these arguments made against allowing companies to choose the center of the main interest. But I think when we talk about decentralized autonomous organizations, we can actually benefit from allowing companies to choose the proper forum. And in order to solve this problem of changing COMI by changing articles of association, what I think could be interesting is to actually provide it in the code itself. So in the code which underlies the operation of the DAO, there could be a forum choice, and the code can be structured in a way that it's really difficult to change ex post. So it will give legal certainty and predictability to all the parties involved. And we have seen already cases where courts had to interpret the choice of the insolvency forum in their legal documents, and we have some support, even if it is a minor one, from courts in that respect. That's my idea. So I think contractualism can be revived and used for these types of digital organizations.
Yeah, I think, Adam, sorry, just a final comment on that. I mean, obviously, these technologies, while they've been around for a decade, are still very much in their infancy. And so I think, much like corporations, when they choose their places of incorporation and certain jurisdictions that are preferred in terms of insolvency regimes, it shouldn't be any different with DAOs. So in other words, the first thing before insolvency they're going to have to regulate is how they resolve disputes. So, a member cannot sue another member if they don't know where this member is and if it's connected to the DAO. So I think self-regulating the place, or rather the venue for resolving disputes, is going to be absolutely necessary, because I think we've known in 10,000 plus years of civilization that no dispute can be necessarily self-regulated. And so at the end of the day, I think DAOs will have to make a choice, and then, jurisdiction and case law will develop out of it. And there will be, of course, be preferred jurisdictions where these disputes are resolved in a way that's more like than others.
Great, thank you. It looks like we have a question from Steve Kargman, and he asks, in terms of COMI for a non-main proceeding, does the notion of a non-transitory economic establishment make any sense in the digital business context?
Yeah, if we look in the definition of an establishment, right, so it has to be non-transitory economic activity with human means and assets. Here we don't necessarily have human means, we don't necessarily have assets that we can pinpoint to a jurisdiction. So in my opinion, we just run into the same problems, but maybe even more difficult, because then there could be many establishments for a business, and for decentralized one like a DAO, I believe that could create a lot of problems, because then you can have as many establishments as potentially there are members of a DAO. But that's just first thoughts that I had when reading the question, but maybe others can add.
Yeah, I absolutely agree with that. I think the factors that we talked about before are really more signs of an establishment than a center of main interest. So I think the problem you really have is that you have several places of potential establishment, no COMI, and then you're back to the question of which one should prevail.
Excellent. Are there any other questions from any of the in-person attendees, or any other questions from the virtual attendees? I am told we have no other questions yet. That being the case, I'd like to thank Maya, Ilya, and Jose for their hard work in preparing the paper and preparing for this panel. And I think we're ready to conclude this unless anyone has any further comments or final comments. Thank you, everyone, and hope you enjoy the rest of your day. And look forward to seeing all of you at some point, hopefully in the near future.
Thanks, guys. We have lunch now for an hour for people in virtual.